Hey, well, good afternoon and welcome, everybody. Thank you for joining us today. My name is Andrew Doffney, and I'm the Instruction and Outreach Librarian at the New Jersey State Library. And I'd like to welcome you back to this part two of this estate planning boot camp. If you're new and you missed part one, their recording is available on our YouTube channel, so I'll send that out in the chat in a little bit so that if you want to go back and watch it, you certainly can and kind of get some of the information that we'll be building upon in today's program. And I also like to welcome back Larry Metzler, who is the president of Apogee Financial Services. And he's been with us before. He's done a great job, and he's going to continue today. We're going to talk about, the last seven of these common mistakes and myths related to estate planning. So just like last time, if you do have any questions, you can submit them to us at any time using the Q&A or the chat features in the Zoom dashboard, and I will address them at the end of Larry's presentation today. I will be uploading the free handouts from last time as well. So if there's anybody new or you still haven't had a chance to get them, I will be uploading them to the chat and you'll be able to access them there. Just like last time, there will be a survey available at the end. If you have time, please complete the survey. We really got some really great feedback last time, so we'd like to hear more of what you have to say. Again, and if you want to talk about personal financial concerns or you want to follow up with more information, you can contact Larry by email or you can schedule an appointment to meet with him, and I'll give that information out in the chat as well. So, and then again, if anybody is new or you need a refresher, this is what your Zoom dashboard should look like. If you're using a PC or a Mac, if you're using a mobile device, the dashboard may look a little bit different, but all of the features will still be there. In the bottom left-hand corner, you can check your audio settings. So if you're using an external listening device like a headset or earbuds, you can check to make sure that it's connected properly there. At any point during the presentation, if there are any issues, you can hit this raise hand button here. That'll alert me and I will send you a message in Zoom and hopefully be able to resolve any problems that you are having. And again, as I mentioned, if you do have any questions, use the Q&A or the chat buttons. Submit your questions to us at any time, and then we'll address them at the end of Larry's presentation. So that is everything that I have for you. So I'm going to turn it over to Larry now to continue.
Thanks, Andrew. Just be with you in just a second. Okay, you should be able to see the screen. We good, Andrew?
Looks good.
Okay, so once again, folks, we'll leave plenty of time at the end of the presentation for questions. If you did miss the first piece of this, as Andrew said, it's recorded. These slides are not necessarily dependent upon one another. They're just fundamentally focused on what we have found over the years to be some issues that people have that they're either unaware of or they just don't completely understand. So mistake number 8, as you can see, is failure to understand the federal gift tax rules. Some folks are surprised to learn that there is such a thing as a gift tax. It's been around since I've been in this business. Essentially, what happens is that any gift that you make in 2024 to any individual more than $18,000 per year is an excess taxable gift. Let me give you an example. At Thanksgiving, mom and dad basically give their kids a check for $20,000 to reduce the value of their estate for whatever reason, or just to have the kids enjoy their money while they're alive as opposed to receiving it when they're deceased. So in that fact pattern, that excess $2,000 would in fact be considered a taxable gift. And the law requires, although very few people actually comply with the law, quite frankly, that a Form 709 is filed. That's a United States gift tax return. If you were on the call last week, you know that the federal estate tax exemption was $13,700,000. That is also the gift tax exclusionary amount, actually $13,610. So in that instance, when you file that 709, no taxes would be paid. You would use part of your credit to offset the tax that would have been due but for the credit. So one might wonder, why in the world would one want to do that? Give you kind of an arcane example here. So let's presuppose that back when Apple stock or Tesla stock was trading at 50, mom or dad gave $18,000 worth of Tesla stock away. So What happens when that stock appreciates? Do we have to then retroactively go back and file at 709 because it appreciated in value? No, we don't. So in many instances, gifts are used in giving low basis stock to the donees to avoid inclusion in the estate should that stock appreciate disproportionately. What happens if mom has the money, dad does not? Mom can make a $36,000 gift, $18,000 for her, $18,000 for dad, even though dad doesn't have any money. So as a per donee basis, $18,000 per person, split gifts, mom and dad chip in $36,000 per year. No gift tax, no return needs to be filed, so forth and so on. As you can see at the bottom of the slide, lifetime exclusion as we sit here, $13,610,000. However, and you can read this at your leisure, there's a whole host of rules applying to prior gifts. One of the problems is let's say back in 2020, mom and dad gifted their home to their kids. And the kids now use that as a residence and then ultimately convert it to a rental. The IRS has 3 years from the date the 709 is filed to file an objection to the valuation. The problem oftentimes arises is no one files a 709. They subsequently sell the asset. The IRS comes back and says, how did you establish the basis in the asset? And if you can't affirmatively establish the basis, the IRS's valuation basically applies, which causes all kinds of income tax problems and estate tax problems as well, and gift tax problems as well. So rule of thumb, I'm a lawyer, I have to tell you what you're supposed to do. Any gift to any donee in 2024 in excess of $18,000, the donee, not the recipient, should file that Form 709. Mistake number 9. Failure to properly plan to protect your assets from being spent down on the cost of long-term care. I can tell you categorically, folks, this is one of the biggest holes in folks' estate planning. They do not address this issue until it's a crisis situation. So here's the belief system. I probably won't need nursing home care or long-term care. Fact, statistically, about 43% of seniors will require some form of nursing home care. 70% will require long-term care prior to death. Give you an example. Mom, grandmom, whomever, hops in the tub, slips, breaks their hip. Oh boy, here we go. What happens? Let's say grandmom is on Medicare. So Medicare will cover up to 100 days of care as long as the care is curative in nature, meaning that mom or grandma is getting better from her hip fracture. Let's say 60 days into it, grandma or mom, whoever fell, we'll say it's grandma, is no longer moving forward. Her rehab basically has plateaued, but she still requires care. As soon as that care becomes palliative, meaning there's no improvement, they have to kick grandma out to a nursing home. At that point in time, the question is who's paying for that and what are the costs? In belief number 2, you say, or we think we have enough money set aside to address the problem. In our area, folks, home care is running right now about $6,000 to $7,000 a month. Assisted living, meaning you're not in 24-hour nursing care, $7,000 to $10,000 per month. And for full-term 24/7 care, anywhere from $10,000 to $14,000. I just had a case come in about 2 weeks ago where this woman's dad is in a nursing home. She's paying $15,600 a month for his care. So you can see that can get pretty doggone expensive pretty quickly. Belief number 3, my primary resident is protected. In fact, it is not. What happens here is that the community spouse, so if grandma is in the nursing home and grandpa is living at home, grandpa is deemed to be the community spouse. Grandpa can continue to live in the house until such time he either passes away or voluntarily or involuntarily leaves the premises. While grandpa in that fact pattern is living there, to the extent that grandma is on Medicaid, a lien is starting to accrue based on every dollar that the state and the federal government pay for grandma's care. And upon granddad leaving the property will be sold and the Medicaid lien will be paid back. So in fact, your residence is no longer protected from the lien accruing. It is protected from the standpoint of the community spouse continuing to live in the home. Belief number 4, my IRA is protected. No, sir, not since 1997. The IRA is part of what they call countable assets. Belief number 5, if I put something in joint name with my child or children, we're protected from being spent down. Unless the child or children can prove contribution, meaning they paid something for the asset. That asset is a countable asset, and it will be brought back into the calculation of what can be recovered under the what they call clawback provisions of the Medicaid rules. Belief number 6, I can transfer my assets now, and in 3 years, I will qualify for Medicaid. Once again, don't confuse Medicare with Medicaid. Medicare is when you turn 65, everybody who's a citizen gets Part A and Part B, which is doctor's care, hospital care, so forth and so on. Medicaid basically is where you no longer have financial assets such that you can pay for your own care. Literally, you are destitute. You cannot have more than $2,000 in your name at any point in time, or you don't qualify. So, in fact, the look-back period is now 5 years, not 3. It's likely that this look-back period will be further extended by Congress. Why is that? Well, we're all aware of the baby boomer generation, how many people are coming onto the rolls, about 10,000 a day still. So if it's 70% likely that that baby boomer population sooner or later will need Medicaid, the government's more likely to make it more difficult for those folks to qualify. So I wouldn't be surprised if in the next 3 to 5 years, the look-back period is extended to maybe 72 months as opposed to 60. Belief number 7, no need to rush into examining the need to make Medicaid transfers. If you wait until the crisis situation occurs, it's almost too late. In many instances, the entirety of this person's life work may be given away for their long-term care after, in fact, they pass and the Medicaid clawback provisions come into play. Belief number 8, I can give away half of my assets to my spouse and retain the balance of my assets for long-term care. Let me tell you how that works. So let's say that my wife and I have $1 million of assets and I have to go into the nursing home. What they do, they take the totality of our assets and they divide it in half. So if I have $1 million, I have to spend down $500,000 before I can file, or before it would be possible, hypothetically, for me to qualify for Medicaid. But that doesn't happen. What happens is that they then start looking at my wife's assets, and you can see under belief number 9, my wife can only retain of her $500,000, $148,420 to be used for her care for the rest of her life. So literally, to kind of summarize, if I have $1 million and I am in long-term Medicaid situation in a nursing home, we have to spend down everything from our $1 million down to $148,420, which my wife can then keep to support her. That's how onerous this system is. This is for your reference. The most important thing I want you to focus on, total resource allowance. This is the amount of money that a person can have in their own right to qualify for Medicaid. If they had $2,001, they're off. So you can see, in effect, this person now is destitute. They have to have spent down all of their money except $2,000. Look back period, once again, is 60 months. Mistake number 10, long-term care planning. Oh, excuse me, still on number 9. I'm sorry. While you have time, what are your options? Do nothing. This is an affirmative decision, as is in any situation. If you're confronted with a problem and do nothing, that is an affirmative decision. Buy traditional long-term care insurance. What are the pros and the cons? Pros are it addresses the issue to some degree. The cons are the benefits may not keep pace with inflation. You need to be healthy in the first instance to qualify. Premiums will continue to increase without a doubt, and money is wasted if you don't use the benefit. What do I mean by that? It's often like your car insurance or your homeowner's insurance. You pay this money your entire life to kind of cover you against the risk of something really, untoward happening. And if you never use the benefit, all that money you've spent on the insurance is wasted. We have come upon a strategy now, I guess, about 10 years ago, in what they call asset-based long-term care. The way this works, I'll show you by way of an example. So here's an example, and that's all this is. This example. Don't use this as being determinative of your situation. So here's Mary. She's age 60. Mary's concerned because she has a history of Alzheimer's disease in her family. In many instances, in absence of an accident or some catastrophic event, predictability oftentimes of requiring long-term care oftentimes is dependent upon your genetic disposition. What do I mean by that? In my family, men have cardiac issues, no Alzheimer's issues, no cancer issues. If you, in your family, when you look at, if you're a woman and you find out women in your family have a problem with Alzheimer's or dementia, from a genetic standpoint, it's more indicative that you may in fact have that type of malady in the future. So let's get back to Mary. Mary has that genetic disposition. She's concerned about having Alzheimer's disease, which would require her to go into a nursing home. Mary's assets are $180,000 in an IRA. She has $100,000 in a money market account, earning 5%. She has $140,000 in CDs, earning about the same amount of money. She's willing to transfer $50,000 from her money market account to an asset-based solution. So what happens when Mary does that? Her $50,000 money from her money market account goes into typically for her, a life insurance policy, which from day one has a death benefit of $116,567. So what do we see here happening? Her $50,000 has been leveraged. So if Mary never uses the long-term care benefit and passes away, her heirs will get the $116,567, as opposed if she had spent that money in traditional long-term care insurance, they would get nothing. The $116,000 buys the long-term care benefit of $116,000, the same amount, and Mary can choose where she wants to receive care. She can get it at home, in assisted living, in a nursing home, wherever she thinks she would be most comfortable and wherever her benefits would last the longest. I think we can say, for the most part, if possible, if we were in a need to require long-term care, we would prefer to stay at home. So once again, you can see the leverage that takes place here in this situation. Now, in order for Mary to qualify for this type of a program, she has to be relatively healthy. She can use, for example, this is kind of silly, but if she has a cane with 1 point on it, she qualifies. If it has 2 or more, she doesn't. If she has a history of falling, she doesn't qualify. If she's already in a nursing home, she doesn't qualify. So what this is, and the reason I'm pointing these things out, is that unfortunately, many people wait until it's way too late. They're already in a crisis situation. They've already been in either diagnosed with some form of dementia. They've had an event where they have consistent falling, where they've been hospitalized, to the point where now they can't qualify for it. So like most things, if we're talking about an insurance benefit, the younger you are, the healthier you are, the more likely it is to get the policy issued. And it will never be as cheap as it is today. I can tell you that with absolute certainty. So don't let the situation kind of bite you. If you're young on the call, talk to your parents and your grandparents about this, because it's getting to a situation where it's getting somewhat out of hand. Mistake number 10, failure to properly select a fiduciary. Well, okay, what in the world is a fiduciary? It's a highfalutin name. Technically, a fiduciary is one person who is in a position of absolute trust and fidelity to their principal. So, for example, the guardian of a person, of a minor child, or a legally incompetent person. When you draft your will, you're going to have to name someone, if you have minor children, who, in the event of your and your spouse's demise, will, in fact, raise your child. That's called the guardian of the person, meaning the person with whom your children will live. That person you pick, obviously, you want to be absolutely sure they're going to try to do is raise your child as in the same light that you would were you here to do that. That person's obligation to always do what is in the best interest of the child. Seems axiomatic, doesn't it? I've had situations where this actually occurred, where the parents wanted the children to be brought up in the home where they were born or the home where they were living when the parents passed away. The next thing you know, the guardian of the estate, which is the assets of the child, are selling the property, doing things that perhaps they shouldn't do. So obviously that breach of fidelity has been breached. So once again, guardian of the person, that is the people who will raise the child. That's the person or persons with whom the child will live. The guardian of the estate is the assets of the child. Prior to them attaining the age of majority, the guardian of the estate will make financial decisions from an investment standpoint, a distribution standpoint, so forth and so on. An executor named in your last will and testament is another fiduciary. A trustee named in a trust, whether it's revocable, testamentary, meaning it was created in your will, or irrevocable. An attorney in fact named under your power of attorney. And then finally, a medical decision attorney in fact, the person named in your advanced medical directive or living will. Let's back up just a second to your power of attorney. There are three forms of powers of attorney. There's what's called a general durable power of attorney. What that means is the minute that you sign it, whoever you have appointed has the same rights in your property as you do. Typically, this is going to be between spouses. If you're going to be naming a successor, which you will be obligated to do, you want to make doggone sure that whomever you name, you trust with your life, because in fact, they have that power over your life, over your person, over your assets. So that's a durable general power of attorney. Second type of power of attorney is called a springing durable power of attorney. As opposed to the general durable, which is activated upon your signature, the springing power basically only comes into force upon the determination of your disability or incapacity. And therein lies a little bit of a conundrum. Who's going to make the determination that Larry's incapacitated or that you're incapacitated, that you can't deal with your financial affairs anymore, that you can't deal with other things in your life? Who makes that determination? Whoever makes that determination will not be challenged. And if it is, guess what, folks? You're going to court for a judicial determination of that fact. So while the durable general power of attorney, no problem as between spouses, make doggone sure that the person you name as a successor, you trust implicitly, once again, because they are a fiduciary. The duty always is to act in your best interest. It's a principal-agency relationship. I will tell you the courts come down very hard on people who have abused those privileges, if in fact they ever find out about it. We've had several cases over the years come through where an elderly person names their neighbor across the street who has been kind of kind to them, and next thing you know, the neighbor's stealing their money. That happens, unfortunately, more often than you might expect. Finally, the third type of power of attorney is what's called a special power of attorney. Typically, a best example I can give you, you're either buying or selling a property, and one of the spouses can't go to settlement, so you appoint your attorney, your counsel, or some other person to go to settlement and sign your name at the settlement table. Meaning it's a one event appointment, and once that event is over, the power is revoked. At the bottom, please make certain to inform the individual you select. And that sounds like, seriously, Larry? I want to say about 8 or 9 years into my career, the person I went to law school with got killed in a car crash, she and her husband. They had 4 kids. They named her brother as the guardian of the person of the estate of their 4 minor children and never asked him if he was willing to serve in that role. So imagine, if you will, first of all, the grief of losing your family member, but then secondarily to that, now 4 little kids wind up on your doorstep and you're responsible for them. Please make certain to talk to the people you select. This is especially important in a medical decision attorney, in fact, because this is a life or death situation. The person or persons you name to be guardians, executors, trustees, and attorneys, in fact, oftentimes that is an intellectual nomination. Do they have the experience, so forth and so on? Do they have the maturity, so forth and so on? When it comes time to, in fact, pulling your plug, put it out there the way it is, You want to make sure the person you name loves you enough to let you go, to do what you need them to do when you can no longer do it for yourself. Pretty heavy stuff, pretty serious stuff. Name several successors. Spouses typically name each other. Hopefully, you have a person or persons you can name to be first successors and second successors. So we'd like to see always two levels down from the primaries, if you will. To the extent that you can articulate it, provide as much personal insight into your expectations, instructions as possible. You can do that verbally. I often say, it makes a lot of sense to have this added to what we call your letter of last instruction so that people know what you would like to do or what you would like to have done in these various circumstances. Mistake number 11, failure to have a power of attorney, failure to have it updated on a regular basis. Well, we've kind of described what your power of attorney is. This is a life document. It is revoked upon your death. Every once in a while, someone will come in and say, "Oh yeah, I settled my granddad's, my brother's, whatever estate under the power of attorney." No, you did not. When you die, your power of attorney is absolutely automatically revoked. As you can see, the belief number 2 there. Once again, we reiterated this in the first session. Institutions, meaning banks, brokerage firms, so forth and so on, have promulgated their own rules, folks, as to how old your power of attorney will be before they won't accept it. I will tell you categorically, from a statutory standpoint, powers of attorney do not expire. However, the banks and what have you basically have their own rules, such that if you had to use a power of attorney in Wells Fargo and their rule is after 5 years, your power of attorney is 6 years, they will not recognize it. So question arises, can I litigate that? Can I sue Wells Fargo in my fact pattern? Sure. But ironically, when the powers of attorney need to be utilized, typically this is in a very serious situation. So you need to make doggone sure that it's consistent with the rules of where you keep your money and where your assets are housed. So I would recommend very highly, if you get a power of attorney drafted, signed, and what have you, check in with your institutions. Whatever institution has the lowest number of years, go back and republish accordingly, if that makes any sense. Mistake number 12, failure to have a living will or an advance medical directive. I don't know if you remember the Karen and Quinlan case. That was a New Jersey case, the first one of its nature. Karen and Quinlan basically was maybe 60 pounds, and she was basically wasting away, and there was just unbelievable litigation that spawned. So the Karen and Quinlan case basically was the first case in New Jersey which formed the basis of our advanced medical directive legislation and statutes. Second case, maybe some of you may be familiar with more so, that is the Terry Schiavo case. And what happened there is Terry had a stroke. She had an advanced medical directive, but it wasn't real clear. It was somewhat ambiguous. And there's a rule of construction in the law, folks. This is basically, if there are ambiguities in your documents, they are construed against the drafter. So you are considered the drafter. So if there's ambiguities in a document that someone is challenging, ambiguities are always construed against you. So in Karen or in Terry Schiavo's case, there were ambiguities. She was kept alive again. She's wasting away. Her husband wanted to do what she wanted him to do, which is allow her to pass away. And the parents kept suing him and kept litigation, and it caused an enormous amount of money to be spent, but probably more importantly, the relationship between the husband and kids and the grandparents was forever breached. So your advanced medical directive, basically the draft that you will get, has typically all of the things that are required to be addressed under the statute, and then you can select what to choose and what not to choose, what you want, what you don't want. Facetiously, I'll share this with you. When folks first get it, there's an example of one of these determinations is, do I want to have a DNR code appended to my chart? And they say, well, geez, I mean, what happens if I'm in the mall and I have a cardiac arrest? I mean, and I just happen to have ironically, my advanced medical directive in my pocket, and someone reads it and goes, oh no, don't try to revive him. No, What happens here is the document itself basically should say something to the effect that in the event that I am in a situation determined by two board certified physicians who in the first instance have examined me and in the second instance have opined in writing that based on what it is that's wrong with me, there is no reasonable hope of my recovery, then and only then does this document really come to life. That's what they call condition precedent. Those two things have to happen before the document has life. So in the fact pattern I gave you, the fact person has the heart attack at the ball, no, of course not. And I, in my workshops, I often say, if I was having a root canal today, and before I got Novocaine to where I couldn't speak anymore, I happened to tell my dentist that I just signed my advanced medical directive yesterday with a do not resuscitate code or insert. And I coded in the chair, should he not paddle me? Of course not. Last time I checked, root canal is not an extremist situation. I'm not going to die from it. So facetiously, by way of example, that's what we're talking about. Much like your power of attorney, pull out the document every 2 or 3 years. Make sure it's still consistent with your wishes. Make sure that your successors are still on board, so forth and so on. Mistake number 13. This is a big one, folks. Failure to properly plan for the eventual income taxation on the transfer of your IRA or other qualified plans, whether they be 401k, 403b, whatever the case may be, upon your demise. You're probably aware of this. For non-spousal beneficiaries pursuant to the Secure Act 2.20 after January 1st of 2020, all distributions from IRAs, qualified plans, must be distributed within 10 years from the date of death of the account owner. This is a boon for the IRS. This is like hit the jackpot. Prior to the Secure Act 2.0, you were probably familiar with the idea of the stretch provisions, which basically said that if I passed away and left my IRA to my child, that child typically could stretch out their required minimum distributions out through their lifetime. So if my child was 50, 60, whatever the case may be, they would be 20, 25, 30 years based on the IRS tables. They could take it out over that period of time, thereby minimizing the taxes. Not the case anymore. So a couple of things you want to think about. If you have large accumulations and you think that taxes will be the same or higher when you retire, and this is an issue for you, should you change for maybe, if you have the ability to, for maybe making traditional 401 contributions or 403b contributions, does the employer provide a Roth alternative? When you retire, we highly, highly recommend that you review the efficacy of doing a program Roth conversion to convert what would normally be taxable distributions in the future to non-taxable accumulations and distributions in the future to avoid this problem. If you've not heard of him, there is a fellow by the name of Ed Slott. He is a nationally recognized CPA, one of the most knowledgeable Roth conversion and IRA specialists. I know from time to time he is on public television. He has like an hour show that talks about this issue. But to capsulize what Ed says is, with respect to Roth conversions, if you believe once again that throughout your retirement life cycle, taxes will be the same or higher going forward in time, each year look at what is the spread between your current marginal tax bracket and the next marginal tax bracket. So let's say you're in the 20% marginal tax bracket, next tax bracket is 22%. And in your calculations, you find out that you have a $10,000 spread between you will, in other words, if I get $10,000 more of income, I will now roll into the 22% tax bracket. In that scenario, Ed Slott would say, and we kind of support that proposition, that you should think about converting maybe $9,000, $9,500 of traditional 401k, 403b, or IRA money into a Roth. Next year, you do the same analysis, typically in the fourth quarter. And let's say at that point in time, you have $12,000 of spread between the two tax brackets. Okay. In that instance, we would convert maybe $11,000, $11,500 to a Roth. So each year, you're going to analyze, does this make sense to consider a Roth conversion? Now, the reverse of that would be true. If you think and your planning has indicated to you you're going to be in a lower tax bracket in retirement, then you would keep things as they are and kind of roll with it. Again, if that makes any sense to you. Okay, finally, folks, failure to properly and legally name guardians of the estate of the person and the estate for your minor children or grandchildren. We addressed that in your will planning. Obviously, you want to name, who's going to take care of the child, who's going to manage the assets for the child, so forth and so on. Here's a fact pattern that actually occurred that no one ever thinks about. Here's what happened. Young couple had 2 kids. I think they were age 3 and 5, I believe. Friday night was date night for mom and dad. They're going to Philly to a restaurant, meet with some friends. 14-year-old babysitter comes over, take care of their kids. Program is mom and dad will be home no later than 11. On the way home, mom and dad are in a pretty bad accident. They are in a hospital. They are unconscious in the hospital. 11:30 comes and goes. 11 o'clock comes and goes. No parents. 11:30 comes and goes. Babysitter's not home. Babysitter's parents. What's going on? I don't know. I tried to call these people. I can't get them on the telephone. 11:30 comes and goes. 12 comes and goes. Right around 12:30, the parent of the babysitter calls the police. By this time, I believe the husband's sister, who was an attorney, I guess she was on his emergency card, got wind of the fact, gets to the house when the police are there and says, look, I'm an attorney. I'm an officer of the court. I will take custody of the kids. And the police officer said, I don't care who you are. You have no right to take custody of these children. And they went into DIFAS, Division of Family Services. Folks, the last place in the world you want your kids or grandkids to ever go is a Division of Youth and Family Services. What I understand, took about 6 days to get these kids back out. So, offshoot of naming the guardians of the person and of the estate in your will. This is a whole different kettle of fish, so to speak. What you want to do, hopefully, you have neighbors or you have family who lives relatively close by, such that when your babysitter comes over, there's a document on a magnet on your refrigerator that basically says, if anything happens like this, that I have appointed these people to take temporary custody of my children. So this never, ever happens. Mathematical probability of that happening, little to none. But if it ever happened to you or anybody you know, trust me, it was the worst nightmare you can conceive. So having said that, I think, folks, that about wraps it up. A little bit shorter period than we did last week. So I'm open to questions.
All right, thank you so much, Larry. If anybody does have questions, please feel free to send them to us using the Q&A or the chat, and then we'll be happy to address them. All right, this goes back to the long-term care that you were talking about before. My friend has paid for long-term care insurance for over 20 years. How can he leverage this asset? And not sure this person understood the example you provided with Mary.
Okay, so that's a classic example of paying that insurance for 20 years. If they never use it, all that money is gone. What happens in real life is, and I had this happen, I can tell you time after time after time, the insurance company continues to raise that type of coverage such that it becomes unmanageable. The people can't pay for it anymore, and therefore the next option they give the insured or the person who owns the policy is a reduction in benefits. The example basically says, I'm going to use other assets that I own. And let me go back to the example. Okay, so here we go. Mary transferred from her money market account $50,000 into a life insurance policy. This is not a traditional life insurance policy that she's buying to have income replacement. This is a life insurance policy with long-term care benefits. Once again, she put 50 grand in from the first instant she did that. She had approximately $116,000 of death benefit. So if Mary passed away, never having to use any of the long-term care benefits, her heirs get $116,000, more than twice what she put in it. Compare that to the example the person's asking about, where the person's been already paying for 20 years. Her heirs or his heirs will get nothing if they do that. If in fact Mary needs long-term care benefits, and let's say she uses $80,000 in long-term care benefits, what's her residual? Subtract $80,000 from 116, whatever's left over goes to her kids. This is a lifetime benefit, folks. Suppose Mary needs this benefit for 20 years. There's a rider in these policies that basically say whatever the monthly benefit happens to be, when the rider kicks in, it continues that benefit for the rest of Mary's life. So what's happening there is Mary is transferring the longevity risk to the insurance company, but she's also leveraging what she has to get that coverage of that initial benefit. I hope that answers the question. If not, please give us a call and I can probably, address it that way.
Somebody's mentioned that they believe they recall allowing a real estate agent to serve as a power of attorney for a real estate transaction during COVID.
Sure. That was a very common practice. Yeah. Yeah. You just want to make sure in those instances that, you're dealing with a settlements taking place in a title company and all the transaction is being handled by that title company to make sure that there's not going to be any hanky-panky with respect to the money.
It's also not uncommon to have someone use a limited power of attorney specifically for the purpose of closing on a transaction when they're unavailable to actually attend themselves.
Yeah, generally speaking, the agents are not utilized simply because there is a conflict of interest there.
Um, why are the banks allowed to ignore the law essentially when it comes to powers of attorneys?
Thank you. I mean, technically they're not, but as I indicated, the problem that you have is that in order to get them to comply, you have to file a lawsuit, and that vitiates in the very first instance. Typically, powers of attorney are used because it's a crisis situation or I have to get something done today. Whereas I can hold their feet to the fire by filing that lawsuit, but that doesn't get the transaction done when I need it done. It will extend out until the case actually comes to court. Who knows? 3 months down the road, 4 months down the road, depending on the size of the transaction. Probably would wind up in small claims court where you could be 3, 4, 5 months before you even get it before the judge. Great point, though.
In 2017, a dear friend passed and left me a portion of her retirement IRA. The current value is around $200,000. So I need to spend down all of this IRA before 2027 because
No.
that's when it was transferred to her. She had 10 years for the disbursements, I think.
Oh. Yeah. In other words, if it was post Secure Act 2.0, yeah, absolutely, absolutely. Well, wait a
And what
minute. No, how? No, no.
it was
That's
in
correct.
2017 the IRA was transferred after the passing.
No, Secure Act 2.0 doesn't apply to that because it's grandfathered.
Um, is Roth conversion sunsetting or likely to sunset? And will income limits be imposed on Roth conversions?
I don't. No, I don't think so. That would be pretty extreme. Again, once again, it's an issue of grandfathering. Um, by virtue of kind of forcing this money out over post Secure Act 2.0, I think the IRS is achieving their goal. Um, in the first instance, the Roth conversion, obviously you're incurring, excuse me, an income tax on that conversion. So their IRS is getting their money early on, certainly earlier than they would have under the normal distribution rules, which start at age 73.
My daughter and her husband are going on a vacation. I'm babysitting their 2-year-old in their home. Do they need to leave me a kids protection plan?
All they need, yes, the answer is categorically yes. And all they need to do, I mean, they can do this themselves, or they can have, their attorney do it for them. It's nothing more than a temporary a custody appointment. Say basically, recite the facts. We're going to Italy for 2 weeks, leaving on such and such a date, returning on such and such a date. During the interim, we have appointed Mrs. Smith to be the custodian of our children for this period of time. And I think if you got notarized and witnessed, and I will tell you categorically, this is not statutorily based. But I'll suggest to you that a police officer seeing a notarized document would accept it in many instances. Can't say absolutely guarantee, but it's better than nothing.
Can you explain what the two doctors should state regarding a DNR?
The DNR is essentially a switch. I either want it or I don't. If we're talking about the advanced medical directive, it's the precatory language that triggers, if you will, the institution of the advanced medical directive in the first instance. So the ones that we create basically say there's two conditions precedent. Two board certified physicians have to examine me, come to the conclusion I'm on death's door, basically no reasonable hope of my recovery, whatever it is that's wrong with me. Give an example. I've got end stage pancreatic cancer. I may have a week, I may have 30 days, whatever the case may be, and I'm going to be dead. But clearly, I don't think in that situation I want to, if I code out, that I want to be resuscitated. So the language basically says I want or I don't want a DNR. It doesn't have specific language as to when and if that were to occur. It's the, again, the conditions precedent in the first instance that apply.
What is an asset-based long-term care, and do you have a recommendation?
Yeah, it's just as an example. The example here is Mary's example that's still on the screen, which is she used $50,000 of her money market account. So she converted an asset from pot A to pot B to obtain the long-term care benefit. If you want more information about how that works, how to go about doing that, please give us a call. That's a very fact-sensitive kind of a question. But the example's right on the screen. In other words, asset-based meaning she used an asset to, in fact, fund this long-term care benefit, as opposed to paying an insurance premium month by month by month, or quarterly or annually, whatever the case may be, in traditional long-term care. I think you can juxtapose those two types of policies.
And this kind of piggybacks on it. How does one go about setting up an asset-based long-term care strategy, which you kind of talked about, and then what are the costs?
Okay, so there's two ways you can approach it. You can say, based on where I live, based on my pension and Social Security, because what happens is when you go into a facility, a nursing home, basically they take, once you are there in a Medicaid program, they're going to take your Social Security, they're going to take your pension. So let's say that's $8,000 between the two of those things, and you're in a facility that it costs $12,000 a month to live there. So you have, under my fact pattern, a $4,000 a month deficit or a gap. So the question would be, given my age, how much would I have to put into this strategy to provide $4,000 a month for the rest of my life? Kind of get back into it. Conversely, you can say, hey, I'm willing to throw Y dollars at this. What does it buy me? It's one way or the other. We approach this. And you get a quotation or an illustration, and then we kind of move on from there to see, is this appropriate for this particular client situation? Once again, folks, the best thing to do if you're interested in this, give me a call and we'll arrange for an appointment, and we can kind of give you more in-depth information about it.
What are your thoughts on irrevocable trust to shield assets from estate tax?
Okay, now that suggests that the person asking that question's estate, if they're an individual, is over $13 million. If it's not, there is no estate tax. If they're married, you can double that up or call it $26 million. If that's the case, by all means, please give me a call. We would address that. So essentially, you would only, again, if we're talking purely estate tax avoidance, the only time you would need an irrevocable trust would be to capture, if you will, assets over and above that threshold, that 13.7 million individual or 26 million joint.
I had a life insurance and paid 2750 per year for 14 years, and then realized when it turned 25 years, the annual payment would be more than 36,000 per year, so I canceled it. What should I replace it with? Should I do what Mary did, and how to proceed?
Oh, wow. Okay. So it sounds like you had a term policy, 20-year term policy that once it matured, basically, and this happens all the time, you reach a certain age, and all of a sudden the premiums become unaffordable. The question would be, if you want to combo up, well, the first question would be, do you still need life insurance? If the answer is no, you haven't accumulated enough assets, you don't need to replace income anymore because of your life cycle, where you are in that life cycle, then what you're doing is you're morphing from a situation where you bought life insurance for income replacement or for mortgage liquidation or whatever the case may be. Now, based on your life cycle, you're moving more into an analysis of protecting yourself against long-term care. And just coincidentally, by doing that, you do have a life insurance benefit. So if I'm correct in sort of where this person is in their life cycle, they no longer need life insurance. The life insurance benefit here is an added, if you will, or an adjunct benefit to basically address the issue that as opposed to traditional long-term care insurance, that I pay. If I never used, I've wasted all the premiums. Here, you're not wasting any premiums. You're guaranteed here to always get more than you put into the policy in the event of your death if you never use the long-term care benefit. So think in terms of life insurance benefit as ancillary to addressing the long-term care need.
I have no children or spouse. Are there any recommendations or common mistakes for financial planning, especially for long-term care? So it'd be a single person.
Ooh, okay. So you have no one to leave your money to. Are there charities involved here that you might want to leave your money to? In which case, you may want to address the long-term care. If in fact that's not the case, so if you're saying, hey, there's no one here that I care about leaving my money to, then in many respects, it comes down to your comfort. If you have to go on Medicaid, spend all your money down, basically, you're in a room with another person. You have to go to a nursing home. Medicaid will not pay any benefits for home care. You won't be able to stay at home. So option A, I'll roll the dice. If I require long-term care, I'm going to spend my assets down. I want to have nothing left. Then I'll go into a Medicaid facility and be in a joint room. As opposed to, I'll take some of my money, put it into a policy like this, and guarantee that I can stay at home if I want. I think that's the trade-off. If the fact pattern is there are no beneficiaries whatsoever, charitable or otherwise.
Um, Going back to one of the previous IGS questions, I think the first one we started with. So the friend who's paying for long-term care insurance, do they have any other options at this time? They don't have money available to purchase a policy like this where there is a death benefit.
No, unfortunately not. No, and it's been my experience that these traditional long-term care companies, basically, as I said before, continue to increase the premiums to the point where the person cannot afford to make the premium payments anymore. And at that point in time, their only option, well, there's two options. They can either reduce coverage or lapse the policy, in which case there's nothing left. So they spent all that money, and it's awful. It's an awful situation. That's why, quite candidly, when I became aware of this strategy that you're looking at, I thought it was a godsend.
Is the asset-based example here, is it specific to New Jersey? Is it federal, or is this a general example?
No, general example, it's state-based, controlled by the Division of Insurance. So any policy issued in New Jersey must comply with all the New Jersey regulations. New Jersey, New York are probably two of the most consumer protective states in the country. So the guarantees are there. If you buy a policy in New Jersey and New York and they say that this is guaranteed, it's guaranteed.
For a long-term care policy, who do we hire to set this up? An attorney, a bank institution?
No, give us a call. We can do this through Apogee, not through the law firm, through Apogee. We are insurance licensed to be able to provide this product.
Or you could speak with your financial advisor. They might have the same.
They may. Yep.
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 Where and how can I purchase death benefit tax-free to heirs?
99% of the time, life insurance payable to a named beneficiary is free of income tax. Not necessarily free of estate tax, depending again on the on the death benefit. Example: I buy $15 million of term insurance. I am the owner of the policy. My spouse, children, whomever are the beneficiaries. I die. What are the tax consequences? No income tax to the beneficiary. That $20 million, if I own the policy, is includable in my estate. The excess, or when I say 15 million, right? The excess over the $13 million credit is taxable for estate tax purposes starting at 40%. Typically, again, 99% of the time, the income tax benefit is free of income taxes.
That's it for questions right now. We can wait a few minutes, see if anybody else has um, any other questions, but anything you kind of want to wrap up with or re-emphasize, Larry?
No, again, there seems to be a lot of questions about this long-term care strategy. And I would encourage people, if you really want to get a free look at how this works, give us a call, make an appointment, and we can address your concerns.
Do stepchildren avoid the death benefit tax?
Do stepchildren avoid death benefit tax? Okay, I'm not sure if we're talking again about death benefit, meaning life insurance proceeds. As I said, to the extent that the benefit exceeded the federal state tax exemption, meaning more than $13 million, right? That's an estate tax issue. It has nothing to do with stepkids because the stepkids haven't inherited anything until the taxes are paid. Look at this a different way. Stepchildren, if you want to acknowledge them to be treated as children of the blood, they are Class A beneficiaries, meaning there's no inheritance tax. Last week, there is no current estate tax in New Jersey whatsoever, irrespective of the size of the estate. So $15 million death benefit, $13 million federal estate tax exemption, $2 million under that fact pattern, taxable estate, 40%, $800,000 in estate taxes. $1.2 million left goes to the kids, tax-free, because the estate taxes have already been paid. If it's a direct distribution of the life insurance proceeds, whether the kids are stepchildren or not. If you remember from the last week, life insurance passes by beneficiary designation. It's not part of the probate estate. It's not subject to inheritance tax.
Is the asset-based combo life insurance and long-term care available for Pennsylvania residents?
Oh, sure. Yeah, yeah, absolutely. Absolutely. Yeah, this is not a state funded program, folks. This is through an insurance company. There's only about two of them, three of them out there right now, depending again whether what state we're talking about that provides these types of policies.
Righty. I don't see any other questions, so I think we can go ahead and end it there. Thank you again so much, Larry, for
Oh, you're
presenting on
welcome, Mike.
this.
You're welcome.
If anybody does want follow-up, I posted Larry's email as well as his schedule link in the chat. So you can go there and contact him if you want more information. Again, this program was recorded just like part one, and so a link will be sent out to everybody as well as a written recap of the program. So look for that in a forthcoming email from me. And I'd just like to extend again my thanks to everybody who attended, and again thanks to Larry and Alex for coming in and talking
Thanks,
with us.
Andrew. Thanks everyone for being on the call.
Thank you all so much.